Constitutional development. Indian Constitution. Constitutional development introduction. The theory of the constitutional development in the including from the present after regulating act in 1773. This is the regulating act. What is the Indian constitutional development in India began then 1773. The first Indian act. Act of 1784 and the successive Sarkar Act 1793 to 1853 Constitution under the East India Company rule. The revolt of 1857 followed the important change in the British administration in India. The rule of East India Company came to in the administration of India came under the direct control of the British Crown. These changes were announced in the Government of India Act 1958. Was 1858 important act was the witness in the act of the 1862, 1892, 1919, 1935 and the final Indian Independence Act 1947. Transfer of the power took place and the Indian patronate independence on the 15th of 1947. Regulating Act of 1773. Regulating Act. Regulating Act. The Government Regulating Act of India. The Governor of the Bengal was designated as the Governor General of Bengal. Governors of Bombay and Madras Presidency to be the subordinate to the Governor General of Bengal. Supreme Court at Calcutta was established in 1774. Bribe system and the engagement in the private trade by the servant of the company was prohibited. Court direct to the report upon the company, revenue, civil, and the military affair in India. This is the Governor of Bengal was sitting and Governor General of Bengal. Governor of Bombay and Madras Presidency to the subordinate of the Governor General of Bengal. The Supreme Court at Calcutta was established in 1774. would direct director to the report on the company revenue, civil and the military affairs in India. Look of director. Civil and military. Yes. Eats Indian Act. Act of 1792. Commercial and the political function of the company were separate. This is the first option is that commercial and the political function of the company were separate. What is the Peace Indian Act 1784? This is the first option is the commercial and the political function separate. Number two is the system of the double government was the start code of director to the manage the commercial affair and the new body board of the control to the manage the political affair. Commercial and company were separate. The second is the double government system. The double government was started. Charter Act, the first Charter Act in the 1813. It abolished the trade monopoly of the company in India, that is, the Indian trade was thrown open the British to all the British merchants. Monopoly was the innate except for the trade in the tea and the trade with China. Tea and trade with China. The financial grant to the promote India literature in the science company to the spend 1 lakh rupees annually for education. This is Charter and the important types is the 1 lakh education system and trade system and education system and the financial grant to promote Indian literature and the science. This Charter Act in 1833. The Governor General of Bengal became the Governor General of India. Governor General of India. The Governor of the Bombay and Madras was the deprived to bear the legislative power. The commercial activities of the company was put to an end and it became a purely administrative body. This was the highest centralization presidency. Charter Act in 1853. The legislative and the executive function of the Governor General Council were separate for the first time. A separate Governor General Legislative Council or the Indian Central Legislative Council was established. Open the competition system of the civil service. An Indian where the allow them participate according to the equality committee was the appointment in the 1854. The Government of Indian Act in 1858 and they abolished the East India Company and that transferred the power of the government territories and the revenue and the British Crown. The Governor General of the Indian destination was the changed to the Viceroy of India, direct representative of the British Crown in India. System the Viceroy of India. System of the double government came to an end with the abolition of the Board of Control and the Court of Directors. An office of the Secretary of State for India was created. A 15-member Council of India to the separate of the state for the Indian was formed. Queen Victoria Proclamation. Queen Victoria Proclamation. Then on 1 November 1850, Queen Victoria Proclamation was announced by the Lord Canning and the Allahabad, which announced the end of company rule India, the full assumption of the government of India. Lord Canning, the Queen Victoria Proclamation was announced by the Lord Canning at Allahabad, which announced the end of the company rules in India and the full assumption of the government of India. Indian Council Act of the 1861. Indian were associated for the British time with the law-making process. In 1862, the Lord Canning nominated 3 Indian to his legislative council: Raja of Banaras, the Maharaja of Patiala, and the Sir Dinkar Rao. There is the 1862 is that Canning nominated the Indian his legislative council, Raja of Banaras, the Maharaja of Patiala, and the Sir Dinkar Rao. It initiated the process of the decentration by the restoring the legislative power to the Bombay and Madras presidency, which was the earlier taken away from the Charter Act in 1933. New Legislative Council for Bengal, North West Front, province and WFP and the Punjab were established. This is the main legislative for Bengal, northwest the foreign province and the Punjab were established. Portfolio system was introduced by the Lord Canning in 1559. High Court is suitable for ordinance during the emergency. The life of the such of the audience was 6 months. Indian Council Act of the 1892. Number of the additional member of the court and the central and the provincial legislative council to the increase. The member were allowed to discuss the process and the cases the financial policy of the government. Indian Council Act of the 1909. This act is also known as the Morley-Minto Reform. Lord Moray, the secretary, Moray was then the Secretary of the State for Indian and the Lord Minto was the Viceroy of India. The 1999, the act was also the Morley-Minto Reform. Lord Moray was then the Secretary for the State for Indian and Lord Minto was the Viceroy of India. The Lord Minto is the Viceroy of India in 1909 and the Lord Moray is the Secretary of the State for India. Size of both the central and the provincial legislative council were increased. Official majority in the central legislative council was retained, but the provincial legislative council were able to have the non-official majority. The member will allow to ask the supplementary question and then make the resolution of the budget. Indeed, were the able to participate for the first time in the Viceroy Executive Council. This is the first time of the Viceroy Executive Council in the this time was the Indian Council Act in 1909. This is the first in the Viceroy Executive Council, first time. This year is the 1909. According to the Satyendra Prasad Sinha, as a law member joined the Viceroy Executive Council, this is the Indian man is the Satyendra Prasad Sinha as the law of member of the joined the Viceroy Executive Council. Either introduced the system of the separate electorate. Under this, the Muslim member were to be elected only the Muslim votes. And thus the act legalized communalities and the Lord Minto came to be taken the father of the communal electorate. The father of the communal electorate is the Lord Minto. Government of Indian Act in 1999. This act is also known as the Montagu Transport Reform. Montagu was the Secretary of the State for India and the Lord Sandford of the Viceroy of India. It is a single subject for the provincial subject. A provincial subject is divided into two parts: the transparent and reserved. The transfer subject to be the administrative by the governor and the aid of the minister. The reserved subject to be the administered by the governor with the aid of the executive council. This was known as the Thalassa, which means double road. This means double road. territories were the introduced for the first time of country. Principle of the separate electorate extend to the Sikh, Indian, Christian, Anglo-Indian, and European. Adolf Francis granted to the limit number of people on the basis of the property tax or division. Central Public Service Commission was set up in the 1926 for the recruiting civil servant. Provincial budget separate for the first time from the central budget. Provincial legislative eligible to the draft budget. The history commission to inquire into and the report on it is the working after was provided. The government of the Indian Act 1935. Shimon Commission report became the basic on the government of the Indian Act of 1935. It provides for the establishment of all the All Indian Federation consisting of the province and the operational state as unit. Division of power into three is federal, provincial, and the concurrent. Introduction of the Theresa at the center. Abolition of the Theresa and the introduction of the provincial autonomy in the province. With the introduction responsible government in the province. Provincial legislative of the Bengal, Madras, Bombay, United Province of Bihar and Assam were made the bicameral. Province of Bengal, Madras, Bombay, United Province of Bihar and Assam. It extended the separate electorate for the depressed classes, the scheduled class, women, and the labor worker. Federal court was established at the head. This is the federal court of established was delayed this time is the 1935. It provide for the establishment of the Reserve Bank of India. And the Reserve Bank of India was this year established in the 1935. And it provide for the establishment of not only of the Federal Public Service Commission but also the Provincial Public Service Commission and Zone Public Service Commission for 2 or more provinces. Indian Independent Act 1947 declared India as the independent and the sovereign state for the August 15, 1947. It that provide for the partition of India and the creation of 2 independent dominion of India and Pakistan. The Constituent Assemblies of 2 dominion would frame and adopt any the constitution for their respective nation. It granted freedom to the Indian peninsula that either to zone the dominion of India or the dominion of Pakistan for the remainder independent. Finally, 15 August 1947, India became the independent nation. Lord Mountbatten became the first Governor General of the new Dominion of India. Jawaharlal Nehru was sworn in as the first Prime Minister of independent India. The Constituent Assembly of India formed in 1957. Parliament of Indian Dominion. Framing of the Constitution. Indian Constitution was framed by the Constituent Assembly in the two 11 months and 18 days. It is the longest constitution in the world. The demand for the Constituent Assembly to the draft Indian Constitution was for the first time raised by the Congress in 1935. The British government accepted this demand for the first time in the principle in the August proposal of 1940. Composition of the Constituent Assembly. The Constituent Assembly was the constituted in the November 1946 through indirect the election of it is the member by the provincial legislative under the provision of the Cabinet Mission Plan 1946. The Assembly consists by the total 389 members, of which the 292 were to be the elected from the province, 93 were to be the nominated from the administrative, the 4 members were to be the nominated from the chief commissioner areas. This province was the elected seat in the proportional to it is the population. Also the seat was the federal allocated to 3 communities, Muslim, Sikh and the Sinhala. To their population, roughly 1 member was to represent a population of 10 lakh. This provincial assembly elected it is the member for the Constituent Assembly through a single transferable vote system of the proportional representation. The representatives of the princely state were to be nominated by the head of the princely state. The Mountbatten Plan of the 13th June 1947 announced partition of the country and the separate constituent assembly for and the proposed state of the Pakistan. Consequently, the member of the Constituent Assembly representing those areas which were to be the included in Pakistan, West Punjab, East Bengal, Northeast Foreign Provincials and WFP, Sindh, Balochistan and the Sylhet district of Assam were no more the member of the Indian Constituent Assembly. What is the assembly was the include the Pakistan is the West Punjab, East Bengal, and the Northwest Foreign Provincial and WFP and Sindh. Balochistan and the Sylhet district of Assam were no for the member of the Constituent Assembly and WFP and the Sylhet district through and the referendum to the remain with Pakistan. Thus, the membership of the Indian Constituent Assembly was reduced to the 299 after the partition, and only 284 members signed the Constitution on the 26th November 1949. Working of the Constituent Assembly. The first meeting of the Constituent Assembly was held on the 9th December 1946, which was boycotted by the Muslim League. Dr. Sasindra Sinha was elected as the temporary chairman, and later that Dr. Rajendra Prasad was elected as the permanent president of the Constitutional Assembly. This is the first prime minister, the first president of India, Dr. Rajendra Prasad. Sri B.N. Rao was the appointment as the legal advisor to the Constitutional Assembly. Jawaharlal Nehru introduced the object the resolution on the 13th December 1946, which was adopted by the Constitutional Assembly on the 22 January 1947. It modified version from the preamble of the Indian Constitution. The facilitated the work of the constitution making and the Assembly appointment 22 committees of which 10 were on the procedural affair and the 12 of the substantive affair. The most important was the second member drafting committee headed by the Dr. B.R. Ambedkar. Drafting committee had Dr. B.R. Ambedkar, which was set up the 29 August 1947. The other member of the committee were and Gopal Shami. This is the other member of the draft committee member and Gopal Shami and Alad Aladev Krishna Shami, IR, K.M. Munshi, Muhammad Sadullah, B.N. Mitra, replaced by M. Madhav Rao. The D.P. Khatyan, who died in 1948, was replaced by the T.T. Namasaria. Enactment of Constitution. Dr. B.R. Ambedkar introduced the final draft of the Constitution in the Assembly on the 4 November 1948, first reading, and the second reading of the same of the Assembly was the complete on the 7th October 1949. For the third reading of the Constitution, the Assembly met on the 14th November 1949, but finished it on the 26th November 1949. The Constitution was the adopted on the same day with the remember and the President signed the Constitution. The Constitution was adopted on the 26th November 1949, which the counting in the preamble 22 part and the 2, 3, 95 article and the 8 schedule. Apart from the preamble, now the Constitution of India has 448 articles in 25 part and the 12 schedules. Enforcement of the Constitution. According to the Article 394, same of the provision of the Constitution relating to the citizenship, election, provincial parliament, and the temporary and the transitional provision contained in the Article 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392, and 393 came into the force on 26 November 1949, and the remaining provision of the Constitution came into the force on 26 January 1950. The Republic Day is celebrated on 26 January. because India was the declared republic on the day in 1950. Earlier 26 January was selected as the date of the commencement of Indian Constitution because of this historical significance. It was on this date of 1930 that the Indian people observed Independence Day. Following the resolution of the Congress session held in the December 1929 at Lahore. The Constitutional Assembly came to in on the 24th January 1950, but it is the immersion at the Provisional Parliament on 26th January till the election of the Lok Sabha. The President of the Assembly, Dr. Rajendra Prasad, was thereupon as the first President of the Indian Republic till the election. According to the Article 395 of the Commencement of India Constitution, the Indian Independence Act 1947, and the Government of Indian Act 1935 are the replaced, but the abolition of the Privy Council Jurisdiction Act 1959 was not the replaced. Jawaharlal Nehru, Sardar Vallabhbhai Patel, and Rajendra Prasad, Maulana Abul Kalam Azad, Acharya J.B. Kirpalani, T.T. Krishnamacharya, and Dr. B.R. Ambedkar play a very significant role in the constitution making. Dr. Ambedkar is the recognition as the father of the Indian Constitution. Dr. B.R. Ambedkar. Criticism of the Constitutional Assembly. Not a representative body of the critics have argued that the Constitutional Assembly was not a representative body as the members were not directly elected by the people of the Indian on the basis of the universal appearances, not a sovereignty body. The critics maintained that the Constitutional Assembly was not a sovereign body as it was created by the proposal of the British government. Federal they said that the Assembly had critiqued the decision with the permission of the British government, dominated by Congress. The critics the sense that the Constitutional Assembly was dominated by the Congress party. Lawyer politician domination. It is also maintained by the critics that the Constitutional Assembly was dominated by the lawyer and politician. The question is when did the Constitutional Assembly of India in first meeting? The first meeting is the December 10, 1946. Who was the first Speaker of the Lok Sabha of the Indian Parliament? This is the first Lok Sabha of the Indian Parliament. G.P. Mavalankar. G.P. Mavalankar. In the Indian Constitution, the method of the election of the President of the Indian is taken from which country? This is the Ireland. In the Indian Constitution, the method of the
election of the president of the Indian is taken from which country? Ireland. Indian Constitution silent what is meant by constitution? Constitution की क्या है? Constitution is the fundamental and the organic law of the nation that establishes the constitution, character and design of the government as well as determine the extent of the sovereign power of the government and the manner in which these power are to be the exercise. Constitution is the supreme law of land. Constitution is the jargon, not the required in the written English as set of rules. Right, written and the unwritten take the set to the establish and the duties, power and the function of the various institutions of the government, regulate and the relationship between them and the define the correlation correspondence between the state and the individual. The silent feature of the Indian Constitution are as follows. The silent sir, longest written constitution. In the written constitution provision that codified into the single legal document. For example, the U.S. Constitution, the Indian Constitution, extra. Example of the country with the unwritten constitution of the Ireland, UK and New Zealand. This is the unwritten constitution. This is the written and unwritten constitution, not the imposed constitution. Indian constitution has been framed by the representative of the people of the Indian through the Constitution Assembly during 1946 to 1949. The Constituent Assembly, however, was elected entirely by the provincial legislative assemblies that were themselves elected on the The Constituent Assembly, however, was elected indirectly by the provincial legislative assembly that were themselves elected on the restricted branches. The representative of the provincial state were the nominee of their roles. With the spirit of it, the Constitutional Assembly could be called a representative body because then the ruling party at the center had decided to give the representation to all the sections of the society as well as to all the shaded of the opinion. The synthesis of the parliamentary sovereignty and the judicial supremacy. The frame of the Indian Constitution have prepared the proper synthesis between the British principle of the parliamentary sovereignty and the American principle of the judicial supremacy. The Supreme Court on the one hand and declared the parliamentary law as the unconstitutional through it is the power of the judicial review. The Parliament, on the other hand, can amend the major portion of the Constitution through it is the Constitution power, integrate and the independent judiciary. The Indian Constitution establishes a judicial system that it is the integrate as well as independent. Fundamental rights and duties. Part 3 of the Indian Constitution guarantees six fundamental rights to all the citizens. The Constitution initially did not provide all the fundamental duties. This provision was inserted in the Constitution through the Constitution 42nd Amendment Act 1976. Directive principle of the state policy. The Constitution provides for the directive principle of the state policy contained in the Part 4, which directive principle of the state policy. Part 4, which are in the form of the positive direction to the state, which the state shall strive to the promote welfare of the people. The Constitution provides for the review of the act of the legislation of both the union as well as of the activities of the executives, union and the state. Francis. The Universal Act of the Francis gives the right to every adult of the country to vote, irrespective of their caste, religion, and the color, education, and the economic condition. This is the Universal Adult Francis. Unique balance of the rigidity and the flexibility. The Constitution lies down the special procedure for the constitutional amendment based on the ease of the amendment procedure. Constitution can be the flexible or rigid in case of the Indian Constitution. Some law can be the easily amendment involving simple majority in the parliament, while other need the special majority and still some other need the assent of both the union and state legislation. Thus, Indian Constitution is the partly rigid and the partly flexible, striking a good balance in it is the federal polity, the parliamentary democracy. In the parliamentary democracy, elections are held at the regular interval of the choosing the representatives of the people. The representatives control to the executive and the council of the minister, who in the turn and the collectivity is responsible to the Indian Constitution is an example of the parliamentary democracy, federal form of polity. Even after the establishment of the federal form of the government, according to the provision of the Constitution, there are the critics who are the dissatisfied with it as it is fully loaded with the strong centralizing tendencies. In fact, some the critics go to the extent of the calling Indian Constitution a the unitary one, with the some the federal future rather than in the federal constitution with the strong unitary tendencies. Emergency provision. The Indian Constitution contained elaborated emergency provision to enable the residents to meet any extraordinary situation effectively. The rationality behind the incorporation of this provision is to safeguard the sovereignty, unity, integrity, and the security of the country, the democracy, political system, and the constitution, single constitution. Unlike the US, which is considered as role model of the federalism, Indian has a single constitution, single citizenship. There is a single citizenship in India. All the Indian citizens enjoy the same political and the civil right of the citizenship, irrespective of their residing state. Three-tier government. Originally, the Indian three-tier government. For the durability and the content provision with regard to the organization and the power of the center and the state. Later, the 73 and 74 Constitutional Amendment Act 1992 have added a third tier of the government, that is the local, which is not found in any other constitution of the world. Independent agencies. The Constitution also provides for the same independent agencies to the perform function allotted to them, like the Election Commission, Comptroller, and the Auditor General, Union and the State Public Service Commission, and the Finance Commission. Source of Constitution. The Indian Constitution has been described as the patchwork. It is the unique document that was derived from the various sources. Our Constitution has the threads taken from the government of the Indian Act 1935. Those officers are the Federal Scheme Office and the Government, Judicial, Public Service Commission, Emergency Provision, and Administration Deals. The other borrowed provision from the different countries and deals and details of those are given in the table below. Serial number, countries, and the borrowed feature of the Indian Constitution. This is the number 1, Australia. Concurrent this federal freedom of the trade, concurrence and the process sovereignty of the two House of Parliament. And 2 number is the Canada. Federation of the Stocks Center. Testing of the resolution power in the center. Appointment of the state governor of the center. Advisory jurisdiction of the Supreme Court. Ireland. Directive principle of the state policy. Nomination of the member of the Rajya Sabha. Method of the election of the president. Japan. Procedure established by law. Soviet Union, USSR, now Russia. Fundamental duties. ideas of the justice, social, economic, and the political in the preamble. UK. Parliamentary government rules of law, legislative procedure, single citizenship, cabinet system, prerogative right, parliamentary privilege, recognition, US, fundamental right, independent of judicial review, replacement of the president, removal of the Supreme Court and High Court, George post of Vice President, Germany, Weimar, suspension of the fundamental right during emergency, South Africa, procedure of amendment in the Indian Constitution, election of the member of Rajya Sabha, France, Republic, ideas of the liberty, equality, and the fraternity in the preamble. This is a previous question. One of the elements of the direct democracy is referendum, equality, free and fair election, universal adult Francis. This is the referendum. The most essential question on the parliamentary from the government in the sovereignty of the parliament, the right and constitution, accountability of the executive to the legislative, independent judiciary. This is the sovereignty of the parliament. Which of the following is not the features of the Indian constitution? Democratic, presidential, republic, and federal. This is the presidential. The constitution of India parliament, because there is in the elected president, there is the Supreme Court, there is in the parliament. The executive is the responsible of the legislature. The answer is the executive responsible to the legislative. The preamble. What is the preamble? Preamble is the regard as the prelude to constitution. It also the content the philosophy of the constitution. Philosophy of the constitution. The preamble was the finalized by the Constituent Assembly in the last. The preamble is the directly related to the objective resolution passed by the Constituent Assembly on 22 January 1947. We the people of India, having the solemnly resolved to the Constitution Indian into a sovereign, socialist, secular, democratic republic, and to the secure to all the citizens, justice, social, economic, and the political liberty of those the expansion, belief, faith, and the worship, equality of the status and the opportunity, and the promote among them all fraternity, assuring the dignity of the individual and the unity and the integrity of nation. In our Constituent Assembly this 26th day of the November 1949 of the hereby adopt, enact, and the give to the ourselves this the Constitution. Purpose of the preamble. Issue that the ultimate power lies with the people of India. The preamble starts with the word we, the people of India. It contains the noble and the grand vision contain the enacting process, that is the date on which the constitution was adopted, that is 26 November 1949. Is preamble as a part of constitution? In the Birwari Union case, the Supreme Court held that the preamble was not a part of the constitution and that therefore could never be regarded as the source of any substantive powers conferred on government under the provision of the constitution. Later in Keshavanand Bharatiya case, the court laid down that the preamble to the Indian constitution was the integral part of the constitution. Thus, after the observation of the Supreme Court in this case, there remained no doubt that the preamble to the Indian constitution is a part of the constitution. Whether the preamble can be amended in the Keshavanand Bharati case, the court held that the being is a part of the constitution. The preamble was not outside the reach of the amending power of the parliament under the Article 368. It was in the exercise of this the amending power that the Constitution 42nd Amendment Act 1976 Amendment, the preamble inserting therein the term socialist, secular and the integrity. This is the article number in 1976 Amendment, the 42nd Amendment, the socialist, secular and the integrity. Philosophy of the Constitution is a sovereign. Sovereignty belongeth to all the people of India and not to those separate states. Sovereignty means the independent authority of the state. It means that it has the power to the administer entirely and to the legislate on any subject without the interference of any other state external power. Socialist. The word socialist was introduced by the Constitution 42nd Amendment Act 1976. Indian brand of the socialism is the term as the democratic socialism or the Fabian socialism. And they strict to the socialist pattern of the society by democratic means, that is that through the parliamentary laws, the socialism means the elimination of the inequality in the income and the status and the standard of the living. This is the mention in the article number 39B and the 39C of the Constitution. Article number 39B said that the ownership, that control of the material resources of the community are so that described as the best to the subs of the common good. Article number 39C said that the operation of the economic system does not result in the concentration of the wealth and the means of the production of the common determined. This is the article number 39C. This said the operation of the system does not result in the constitution of the wealth and determine the production to the common determined. These are two most important provisions explaining socialist role as the provide in the direct principle of the state. Secular. It is the added by the Constitution 42nd Amendment Act 1976. This is the at the secular is the 1976. The meaning the sought to be the given to the term has been that of the treating all the religions alike, given the respect to all the religion. Secularism means religions neutralisms on the part of the state. It means the respect for the diversity based on religion. The state can give the equal assistance to all the religions, and that is the Indian government provide the assistance to the cause pilgrims and also the Hindu pilgrims who go to the Manasrovar without any the discrimination. Democratic. Democratic form of the government is one of the basic features of our constitution. This cannot be altered even by an amendment of the constitution. Democracy means government by the people. Democracy means government by the people. We have added the representative democracy or the indirect democracy. The democratic element is the main factor in the article number 326 of the constitution is the provide of the universal at all Francis. Republic. The concept of republic depicted the represents of the elected and the state and the not and the hereditary monarchs. The head of the union is the president who is the elected of the fixed tenure by and the electoral college of the representative of the people. Justice. The people promise the justice to all the citizens. Justice is the federal defined as the social, economic, and the political. Social justice implies that all the citizens under the equality, irrespective of this their status in society. The aim of the social justice has to be the achieved through the Article 15. Right against discrimination. Article 16. The equality of proportionality in the public employment. Article number 17 is the probability and the untouchability. And the article number 18 is the abolition of the title of the prevent social discrimination, economic justice. Article number 39 direct the state to try to the secure that the citizens have in the adequate means of the livelihood, that the ownership and the control of the material resources of the community are so the distributed so as to the subserves the common good, that the operation of the economic system does not result in the concentration of the wealth and means of the procedure to the common determine that there is the equal pay for the equal work for the both men and the women. Political judge mean the equal share to all the citizens in the political process of the country. Article number 19.1a provide for the freedom of the speech on the expression to all the citizens. Article number 326 provide for the universal adult the Francis. In this regard, it is the important to note that the political justice is the main lens without the social and the economic results. Right? Democracy cannot be the established unless the certain minimal right are asserted to every member of the society. The preamble mentions this the individual right as the liberty of through the expansion, belief, faith, and the ownership, and these are the guarantee against all the authorities of the state by the Part 3 of the Constitution by the Article 1925-28, equality of the status of the opportunity. The granting of the right to the individual would be the mainlands unless all the inequalities are the removed from the society and is the individual is the set of the equality of the status and the opportunity, unity and the integrity, unity among the inhabitant of this the great nation was the first requested for the meaning and the independence of the country, as well as to make the democratic experiment democratic experiment. The idea of the unity has been done buttressed by the aiding the work and the integrity of the nation in the preamble by the Constitution 47 Amendment Act in the 1979. Noted that the sovereignty illustrated by the frame of the Constitution will be the essence and not only by the abolition untouchability among the different sub of the same community, but the abolish all the communal or the sectional or even the regional anti-social feeling whose the strength in the way of the unity of India. Dignity. The fraternity, however, the member with the exception unless the unity on this of it is the member is the dead. The constitution said to the essay is the objective by the granting equal the fundamental right to is the individual and as a member of the diocese having the part 4 of the Constitution. That substantive which one of the following was not the originally included in the preamble to the Constitution of India, providing socialist secular republic, and that this is the push of the following the clause do not originally include the preamble is a secular is a original not a originally Constitution. This is the act in the 42nd Amendment Act 1976. The secular is the term the secular was the added to the preamble of the Constitution of Indian by 40 Amendment, 41 Amendment, 42 Amendment, and 43 Amendment. 42nd Amendment. This is the 40 Amendment, 41 Amendment, 42nd Amendment, 43rd Amendment. This is the answer is the 42nd Amendment. At the time of the instrument, or at the time of the instrument of the Constitution, which one of the following ideas was not included in the preamble? This is the socialism, liberty, and the justice, equality. This is secularism. Secularism, liberty, equality, justice. The Union and the Territory. Article 1. The name and the territory of the Union. Indian, that is Bharat. Indian, that is Bharat, shall be a union of states. States. India, that is Bharat, shall be the union of the states. The states and the territory here of the shall be the specified in the first schedules. The territory of India shall the comprise of the territories of the state. The union territories is specified in the first schedule. The union territories is specified in the first schedule, and such other territories is may be the accurate. The expansion union of India should be the distribution from the expansion territory of India, while the union of the Indian consists of the 28 states which enjoy and the constitutional relationship with the center. This is 28 states. The territory of the India included in the entire area over the which and the sovereignty of the Indian. The Indian Union is not the result of an agreement among the states. The state do not enjoy the right to shift from them. Thus, we can conclude that the Indian Union is the despicable. Article number 2. Admission of the establishment of the new state. The Parliament may by law admit into the Union or the established new state on such the term and the condition as it thinks fit. Parliament may by the law admit into the Article number 3. Formation of the new state and the alteration of area boundaries of the names of the existing state. The Parliament may by law form the new state by the separation of the territories from any the state or by the unity for two or more the state or part of the state or by the unity any territory to the part of the any state. Increase the area of the state. Diminish the area of any state. Alter the boundary of any state. Alter the map of any state. Process of the formation of any state. Article number 3. Deal with the power of the Parliament or to the access in the area and the boundary of the state. The bill must be the introduction in the either House of Parliament with the recommendation of the President. This is the first. In the second step is the House of the Parliament with the recommendation of the President. Before it is the introduction in the Parliament, the President has to refer the same to the concerned state legislative which has to express into opinion within the time frame set by the President. The opinion of the state is not the binding on the Parliament after the expiry of the time limit set by the President. It is the present judgment state has given that it is the view after the introduction in the Parliament, even if the bills language in 1953. This is the first of the basic language in 1953 is the Andhra Pradesh. The State Reorganization Commission. In December 1953, Prime Minister Jawaharlal Nehru appointed the State Reorganization Commission to prepare for the creation of state on the linguistic line. This was headed by the judicial Fazl Ali, and the commission itself was also known as the Fazl Ali Commission. What is the Fazl Ali Commission? The effort of the commission was overseen by the Govind Vallabh Pant, who has served as the Prime Minister from December 1954. The commission submitted a report in the 1955 recommending the reorganization of the Indian state. The State Reorganization Act. The State Reorganization Act in 1956. The major reform of the boundaries and the governments of India, state and the territories. Linguistic. The Act reorganizes the boundaries of the Indian state along the linguistic line. The linguistic reorganization continues right after the 1956 SRC and the 1956 to 1966. 1956 Naga Hill Transition area was the part of the Assam as UP. This is the Naga Hills Transition area. And 1961 Goa joined the Indian Union and with the European colonialism came to an end on the subcontinent. The 1962 the Puducherry official became a part of the Union. In 1963 Nagaland was the granted statehood. And now is the 1963 Punjab, Haryana, UP, Himachal Pradesh and Chandigarh were created. 1960 Gujarat and Maharashtra were the carved out of the Bombay. Akali Dals. The protest for the linguistic reorganization led to the former states of the East Punjab, Patiala, and the East Punjab State Union and the Himachal Pradesh. The fixing the Northeast Jinsao, 1991. 1991 UT Himachal Pradesh was the granted statehood. 1972 the Manipur and the Tripura were the granted statehood. Mizoram, Meghalaya and the Northeast Foreign Trade Agency were the of the Assam as it is. 1975 the protectorate of India until 1975 the protectorate of the Indian until then the Sikkim joined the Indian Union after the referendum. 1987 UP's Manipur and the Arunachal Pradesh became the state and the state of Goa. The state of Goa, Daman and Diu was split into two, the state of Goa and UP of the Daman and Diu. North-Eastern Frontier Agency later renamed as the Arunachal Pradesh by By the 1975, the northeastern region assumed it is the current boundaries. 1991, Delhi was given the national capital territory and given the legislative assembly with the power jointly shared with the central government. World Fashion Bank return in the new millennium 2000 question. 2000 is the Uttaranchal, Jharkhand and the Chhattisgarh were created. Following law standing regional demand these three states were the craft of the Uttar Pradesh, Bihar and the Madhya Pradesh. Dispute began with the Telangana in that Hyderabad was the made by the dual capital for the state for in the period of the 10 years. 2014 Telangana attained statehood. 2019 the split of the Jammu and Kashmir. There is the first time in the state is the being split into two UTs, Ladakh and Jammu and Kashmir. Timeline. For the formation of the Indian state and the Union territories, this is the timeline. Indian state 28, Uttar Pradesh 1947. The state has Uttar Pradesh is 1947. The state has been in the confluence of the culture, religions, and art. To improve administration, the British united Ut and the Agra regions and called it Union Province. In 1950, it was the renamed Uttar Pradesh United Province. United Ut and the Agra region. West Bengal 1947, winning the Battle of Pilsari-Ghat. British the entry to the Indian and the Bengal was there the administrative capital. In the 1905, Bengal was the partitioned into East and West Bengal, but by the 1911 it was the reunited. The Hindu-Muslim right in the run-up to the partition, the Hastings, the division of Bengal with the East Bengal becoming the East Pakistan and the West Bengal becoming the state of the Indian Union. Rajasthan in 1948, known as the Rajputana under the British India, the recently came together in 1948 to form the United State of Rajasthan. The May 1949 it was the renamed United State of the Greater Rajasthan, and in 1956 the state of the Rajasthan was born. Greater Rajasthan in the 1949 and the state born in the 1956. Jammu and Kashmir 1948. In the October 1948, the Dogra King Maharaja Hari Singh signed the instrument of the association to Indian, and in the 1956 Jammu and Kashmir complete the process of the merging with the Indian Union. 2019 Jammu and Kashmir was the bifurcated into Union territories, Jammu and Kashmir and Ladakh. And the Jammu and Kashmir was the made the Union territory with the assembly, and the Ladakh will be the separate Union territory with the no legislative. Assam 1950, ruled by the Ahuns for the over approximate 600 years and current is 598 years. Assam became the British protectorate in the 1826 when the Burmans handed the territory of the British, the Yandobo. Assam was separate from the Bengal in the 1874. In the 1912, it was made the Assam province under the British rule. Greater Assam included the Meghalaya, Nagaland and Mizoram. Greater Assam is the Meghalaya, Nagaland and Mizoram among other areas before they became the independent state. Orissa, 1950. Orissa was made as a separate province in the 1936 by the British and in the 1950 became the state. It was then renamed in Orissa and Odisha in 2011. Bihar, 1950. It is the format as the state in 1950. Tamil Nadu in the 1950. It was the Madras presidency was the reorganization as the state in the 1950 and the renamed the Tamil Nadu in 1969. This is the Tamil Nadu is a rename. The first name is the Madras presidency and rename is the 1950 1969. Tripura, 1956. Surrounded by the Bangladesh on three sides. Tripura renamed as the Union Territory till 1972 where it became an independent state. Madhya Pradesh. 1956. What was the central province and the Virar? Under the British Union, the merged with the Madhya Bharat, renamed their Pradesh and the proper two from Indian second largest state in the 1956. Kerala, 1956. Former state of the Trivandrum and the Kosi were the merged along with the Malabar who from the state of the Kerala in 1956. Karnataka, 1956. Mysore state was created by the bringing together all the Kannada speaking region together in the 1956. The state was renamed Karnataka in the 1973. Andhra Pradesh in 1956. Post independence in the 1953, all the Telugu speaking region were separate from the erstwhile Madras presidency and unified as the Andhra Pradesh in the 1956. At the time of the reorganization of state, Hyderabad state was merged with the Andhra Pradesh and the state official it is the existence post formation of the Telangana in the 2014. In Italy, the Amravati was the villain who is the new capital of Andhra Pradesh. Andhra Pradesh new capital name is the Amravati. But in the January 2020, the government of the Andhra Pradesh had introduced Andhra Pradesh decentralization and the inclusive development of all the region bills 2020. Internet to the fix their capital to with the executive, judicial and the legislative centers rather than the board at the new capital city. The State Assembly had passes the bill, but the Legislative Council installed it as the chairman referred it to the select the committee for the further scrutiny. Maharashtra. Maharashtra 1960. At the time of the independence, Bombay province popular in the large part of the western India. In 1960, the state of the Maharashtra and the Gujarat were the formed as the independent state. Gujarat, 1960. The part of the Bombay presidency in the British India, Gujarat was the separate and the formed as in the independent state in 1960. War. 1961. This Portuguese colony was liberated in the 1961 by the Indian Army and made part of the Union Territory along with the Daman and Diu. The state of the Goa was formed in 1987. With the Daman and Diu, the continue to the rename as the Union Territories. Nagaland 1963. In 1957, the Naga Hills traditional area was brought under the central control and the administrative from the Assam. With the increasing force and the protest for all the separate identity to the preserve, it is the unique culture. The region as the separate from the Assam and the state of the Nagaland was formed as the 1963 is a Kohima was the capital. Punjab 1966. The post-independence the presently state of the Patiala was merged with the 8 other the similar state who from Patiala and the Punjab State Union PEPSU. In 1956, this the region was merged with the rest of the Punjab and in the 1966 Haryana was separate as the independent state. Both the Punjab and Haryana share the Chandigarh as it is the capital, which is the Union Territory. Haryana 1966. The created from the Punjab in 1966. Himachal Pradesh 1971. Himachal Pradesh was created with the margin of the 30 recently states in the 1950 and in the 1956 was declared as the Union Territory. It became the independent state in 1971 with the Simla as it is the capital. Manipur 1972. Hold the Manipur the Green independent along with Indian is 1947. It is joined the Indian Union as the part C state in the 1950. In the 1956, it became the Union Territory and became the independent state in 1972 with the Imphal as the capital. Meghalaya 1972. The northeastern state of the Meghalaya was formed as the autonomous state within the Assam in 1970. It became a separate state in 1972 with the Shillong as the capital. Arunachal Pradesh 1972. The strategically important state of the Arunachal Pradesh was the part of the North-East Frontier Agency Nepal and controlled by the central government but was the part of the Assam region. In the 1972 it became the Union Territory and in the 1987 became the independent state of the India with the Itanagar as the capital. came. 1975. This the peaceful state was the Indian protectorate in united the margin with the Indian Union as the independent state in the 1975 with the Gangtok Acts. It is the capital Gangtok as it is capital Mizoram. 1987. This was the district of Assam and was the declared the Union territory in the 1972. After the peace accord was the signed with the Mizo Nation Forum in the 1986. Mizoram was declared and the independent state in the 1987 with the Aizawl as it is the capital. Chandigarh 2000. The central Indian state of the Chandigarh was the carved out of the Madhya Pradesh and the formed as the independent state in the 2000 with the Raipur as the capital. Chhattisgarh is 2000. The central Indian state of the Chhattisgarh was the carved out of the Madhya Pradesh and the formed as the independent state in the 2000 with the Raipur as the capital. Chandigarh is the United Territory. UT Jharkhand 2000. The tribal dominant state was the carved out of the Bihar and the man and the independent state in 2000 with the Ranchi as the capital. Uttarakhand 2000. The hill state of the Uttaranchal was the carved out of the Uttar Pradesh as the independent state is the 2000 with the Dehradun is the capital. In 2007, the state was renamed as Uttarakhand. Telangana 2014. The state was carved out of the Andhra Pradesh as the independent state in the 2014 with the Hyderabad as the capital. The demand for the independent Telangana dates back to the times of the reorganization of the Indian state in the post-independence period. Out of this, Delhi, Puducherry and Jammu and Kashmir has legislative and the Ladakh. Recently, Dadra and the Nagar Haveli and the demand and due margin of the Union Territory Act 2019 was the passed. The Act amended the first schedule to the margin the two Union territories into the UTs of the Dadar and the Nagar Haveli and the Daman and Diu. Amendment to the first schedule of the Constitution is not the recognition as the constitutional amendment under the Article 368 of the Constitution. Union territory is the 8. The number 1956 Delhi as the Union territory. 1956 Lakshadweep. 1956 Andaman and Nicobar Island. 1961 Dadar and the Nagar Haveli. 1963 Puducherry, original name Pondicherry. Under the Indian control sign 1954, renamed the Puducherry is 2006. 1966 Chandigarh. 1987 Daman and Diu, yearly part of the Goa, Daman and Diu. 2019 Jammu and Kashmir. 2019 in the Ladakh. When was the Mizoram converted into the Union Territory? The Mizoram in the 1972. Identify the correct chronological order in which the following state in state of the Indian were created Andhra Pradesh, Punjab, Mizoram, Meghalaya. This is the Andhra Pradesh, Punjab, Meghalaya, Mizoram. Which of the following is not the feature of the Indian Constitution? The article number 370 of the Constitution. Citizenship. Article number 5 to the 11 under the part 2 of the Constitution deals with the law relating of the citizenship. This is the article number 5 to 11 part 2. Constitution with the laws relating to the citizenship of Indian at the commencement of the Constitution, that is the 26th January 1950, as regard the citizenship of the Indian is subsequent to the commencement of the Constitution. The provisions are the contained in the Citizenship Act 1955, enacted by the Parliament under the Article number 11. Who is citizen? Individual citizen. This is the individual is a two part. Number one is the part is the citizen alliance. This alliance is the two part of the friendly state and of the enemy states. A nation that consists of the individual who can be characterized as the citizen and alliance. A citizen is an individual who enjoys full the membership of the political community. It means that he enjoys all the political and the legal right. Provision of the citizenship under the Constitution. The Indian Constitution does not have any elaborate provision regarding citizenship, but it laid down the certain basic principles relating to it. With the provide for the single citizenship. Article number 9. Persons voluntarily acquiring citizenship of all the foreign state to be the citizen. The prohibited due the nationalities. Only the exception was the Jammu and Kashmir, which had the due the citizenship. The Union government on the 5 August had the script the provision of the article number 370 of the Constitution that the granted special status over the Jammu and Kashmir. As such, there is no the exception to the single citizenship now. It merely describes who the 26th January 1950, that is on the date of the commencement of the Constitution, are the citizen of India. According to the article number 5, at the commencement of this the Constitution, every person who has his the domicile in the territory of India and who was born in the territory of India, or either of the whose parents who was the born in the territory of the India, or who has been the ordinary resident in the territory of India for not less than 5 years. Implementally, proceeding such the commencement shall be the citizen of India. According to the article number 6, the person who has the migrant to the territory of India from the territory now the included in the Pakistan shall be the demand to be a citizen of the Indian and all the commencement of this the constitution if he or either of these the parents or any of these the grandparent was the born in Indian as the defined in the Government of Indian Act 1935. In the case that whether such the person has shown the grave before the 19th day of July 1948, he has been the ordinary resident in the territory of the Indian since and the date of his the migration or in the case where the such the person has shown the migrate on or the after the 19th day of July 1948, he has been the registered as a citizen of India by and the officer appointed in that the behalf by the government of the Dominion of India on and the application made by him that therefore to the search the officer before the commencement of this constitution in the form and the manner prescribed by the government and provide that no person shall be so registered unless he has been the resident in the territory of Indian for at least 6 months immediately preceding the date of his the application. Article number 11 empowers the Parliament to make the law with the respect to the acquisition or the termination of citizenship after the return. After the commencement of the constitution. In the exercise of this power, the Parliament enacted the Citizenship Act 1955, which was the amendment in the 1986 and 1991 models of the requiring Indian citizenship. The Citizenship Act of the 1955 prescribed 5 way of the requiring citizenship via birth, descent, registration, naturalization, and the incorporation of the territory by birth. A person born in Indian on the after 26 January but before 1st July 1987 is a citizen of the Indian by birth, irrespective of the nationality of these parents. A person born in the Indian on or the after 1st July 1987 is considered as the citizen of India only if either of these the parents is in the citizen of the Indian at the time of the birth. The first is the 1st July 1987. A person born in Indian or on or the after 3 December 2004 is the considered as a citizen of Indian only in the born of the is the parents are the citizens of one of the parents is in the citizen of Indian and the other is not and the illegal migrant at the time of the birth. The children of the foreign diplomat posted in the Indian and the enemy aliens cannot acquire the Indian citizenship by the India by descent. A person from the outside India on the after the 26th January 1950 by the before in 10 December 1992 is the citizen of India by the descent if his father was a citizen of India at the time of his birth. A person born the outside India or the after the 10 December 1992 is considered as the citizen of the Indian or the either of his parent is the citizen of the Indian at the time of his birth. From the 3 December 2004 onward, a person born the outside Indian shall not be a citizen of Indian by the descent unless is the birth or the registered at the Indian consulate within 1 year of the date of birth. The application for the registration of the birth of the minor side. This is the application of the registration of the birth is the minor side, one of the date of the side. Two in the Indian consulate shall be the accommodation by and the undertaking in writing from the parents of such the minor child that he or she does not hold the passport of the author country by the incorporation of the territory. If any new territory is the incorporate, the government of India shall specify the person of the territory who shall be in the citizenship of India by registration. The central government, while on the application registered as a citizen of the Indian any person not being the illegal migrant if the belongs to any of the following categories, namely the person of the Indian origin who is in the ordinary resident in India for the 7 years before the making and the application of for the registration. A person of the Indian origin who is an ordinary resident in any country or the place outside uh, undivided India. The person who is married to the citizen of the Indian and this is the ordinarily resident in India for the 7 year before the making and the application for the registration. Minor children of the person who are the citizen of has and the capacity whose the parents are the registered as the citizen of India. Now, a person on the full age of the capacity who has been the registered as and the over as the citizen of Indian card holder for 5 years and who is the ordinary resident in India for 12 months before the making and application for the registration. A person shall be the demand to be of the Indian origin if he or the either of his parent was born in the undivided India or in such another territory who is become the part of Indian after the August 1947. All the above the categories of the person must take on the oath of the allegiance before they are the registered as the citizen of India. This is the Indian citizenship is the three part. Number is the single citizenship and number two is the three categories related to the citizenship and the Citizenship Act 1955 provide the acquisition and the loss of citizenship. Number in three categories unit of the citizenship. This is the number one is the person domiciled in India. Number two is the refugee who the migrant to Indian from Pakistan, Indians living in other countries, and the Citizenship Act 1955. This is the types is the two types. Acquisition of the citizenship and the loss of citizenship. This the acquisition of citizenship is the five types: the by birth, by descent, by registration, by naturalization, and then by incorrect incorporation of territory. Loss of citizenship by renunciation, by the termination, by deprivation. So by neutralization, the central government may want the applicant grant a certificate of the neutralization to any other person not being an illegal migrant if he the possesses the following qualification: that he is not the subject or the citizen of any country where the citizen of India where the applicant from the become the subject of the citizen of that the country of the neutralization, that if he is a citizen of any other country he undertakes to the renounce the citizenship of the part of the country in the event of his the application for the Indian citizenship in the except that he has the either the resident in the Indian or in the service
Hello?
of the government in India or the
Hello?
partly
Ah,
the one or the partly the
तो अस्सी
other that throughout the period of 12 months and immediately preceding the
Bagian
death
laut
of the
sisma itu
application,
seperti
that
video.
during the 14 years immediately preceding
Bagian
the
dia
said
lama,
period
ini
of the
kan
12 months he has the either the resident in the Indian or been
tapi
in
kulit sampai sini.
the service of the government in India or the
Dia kan awak
partly
biar gitu.
agreement is not less than 11 years, that he is of the good character, that he is had the adequate knowledge of the
Orang
language
yang-
specified in the 18th schedules to the constitution, that in the event of the certificate of
sizing
the
বন্ধ দিছি।
constitution being the granted to him, he the integrate to the reside in India or to enter into or the continuous in the service under the government in
Iklan.
India or the under and the international organization of whose the Indian is a member or the under the society company or body of the person established in India. However, the government of the India may the waive all or any of the above the condition for the neutralization in the case of the person who has the related this discrimination service to the science, philosophy, art, literature, world research, or the human progress. Every Netherlands citizen must take and the oath of the allegation to the Constitution of India, laws Indian citizenship by renunciation. When and the Indian citizen and the acquiring the citizenship of the another country voluntary surrender his or her the Indian citizenship, it can be the termed as the renunciation. Government of India may or may not the accept by the request by termination. When and the Indian citizen acquires the citizenship of another country but does not the voluntary surrender the citizenship of India, is the citizenship can be determined by deprivation. By deprivation, a citizen of the Indian may be deprived of his the Indian citizenship by and the order of the central government if the government is the satisfied. The registration or the certificate of the neutralization who the obtained by means of the fraud the representation or the conservation of any the material fact or he or she the during in the war in which the Indian may be the engaged unlawfully the career on the trade or the communication with and the enemy or with 5 years of his registration or the neutralization or nutrition he has been the sentenced to the imprisonment for not less than 2 years or he has been the ordinarily residing out of the Indian continuously for the 7 years and during that the period he has the neither been the any times the student of a educational institution nor in the service of the government of the Indian or of any international organization of which Indian is the member nor the registered annually in the prescribed manner at and the Indian consulate is the intention to the retain his the Indian citizenship right exclusively enjoyed by the citizen. The following rights are the exclusive enjoyed by the citizen of India. Article number 15. Right against discrimination. Right 16. The article number 15 is the right against discrimination. Article number 16 is the equality of the opportunity on in the public employment. Article number 91. 19(1)(6) democratic freedom, right to freedom of the speech and the expression, right to association, right to assemble, right to move the freely throughout the territory of India, right to reside and settle down in any part of the country, right to end the occupation, trade or the profession. Article number 29 and Vice President George of the Supreme Court and the High Court Comptroller and the Auditor General members of the Election Commission. Citizenship Amendment Act 2019 CAA the CA provide the Indian citizenship for 6 persecuted religions minorities from the Pakistan, Afghanistan and Bangladesh who are the Hindus, Sikhs, Buddhists, Jains, Paris and the Christians. The act aimed to make the sense in the Citizenship Act, the Passport Act and the Foreigner Act. The amendment relaxes the requirement of the neutralization from the 7 year to 5 year as the specific condition for the applicant belonging to this 6 religion. The card of that the citizenship in the December 31, 2014, which mean the applicant should have the entered and yet on or the before that the act at that is the provision on the citizenship for the illegal migrant will not apply to the tribal means the Assam, Meghalaya, Mizoram and the Tripura as included in the 6th schedule of the constitution. It will also not apply to the areas under the inner line. The permit under as the Bengal Stand Frontier Regulation 1873. Freedoms. Which of the following method is not the provided by the Citizenship Act 1955 to uh, acquire Indian citizenship? By birth, by desert, by registration, by accessing right to vote. 55. The by accessing right to vote. Answer is correct. Which article of the Indian Constitution was the empowered the Parliament to the regular the citizenship matter? This is article number 5, 6, 7, 11. 11. The answer is 11. The concept of the dual citizenship in the Union of Indian to the person of Indian origin, PIO, person of the Indian origin, belonging to the some the specified countries was recommended by the Ashok Mehta Committee, L.M. Singhvi Committee, Rajamanar Committee, and the Balwant Rai Mehta Committee. This is B is the L.M. Singhvi Committee. Fundamental right. Originally, there were the seven fundamental rights in the Constitution, but the right to the property was the made the legal right under the Article 300A by the 44th Amendment, 1978. The consequently, at the present, there are the six fundamental rights in the Constitution. The legislative of the state do not have the power to enact law with the respect to the fundamental right, and only the Parliament has such a right. It should be the noted that the certain the fundamental right as the given in the article number 15, 16, 19, 29 and 30. This is the fundamental right. The article number 15, 16, 19, 29 and 30 are the available to the citizens of India, and rest of right are the available to the citizen and the alliance alike. Silent results of the fundamental right. Integral part of the Constitution. The fundamental right have been the map and the integral part of the Constitution, and the hence that cannot be taken away by the ordinary legislation. Any law passed by any legislator in the country would be the declared null and void if it is the derogatory to the right granted by the Constitution. Comprehensive and the details. The right immigrate. The right to immigrate in the part 3 of the Constitution are the very elevated. Each article has been described with it is the scope and the limitation. Right are qualified. The fundamental right of the people are not the absolute except the right against the untouchability. They are the qualified with the limitation and the reasonable restriction in the collective interest of the society. a whole describing the scope of is the right. The Constitution also the describe it is the limitation. These have been the laid down for the protecting public health, public order, morality, and the security of India. Some exceptions are also the provide to the fundamental right through their the non-applicability to member of the security and law and the other related forces during the martial law and for the certain law necessary for the socio-economic reform. Enforceability of right. Fundamental right have been the made the justificable right means if any of these the right are the violated by the government of or the anyone is the individual has been the right. Individual has the right to the approach the Supreme Court or the High Court for the protection and the enforcement of his the fundamental right. Thus, the Constitution not only grant but also the guarantees this the right. There are the elaborated instrument to the protect this the right such as the right to constitution remedy, public interest legislation, and the Human Rights Commission.